Hello everybody and welcome to this new Privacy Rules Miniseries. My name is Alessandro Di Mattia, Legal and Executive Assistant at Privacy Rules. And today I'm joined by our expert from the US, that is Michael Nitardy, attorney at the law firm Frost Brown Todd. Mike is an expert in privacy and data protection, and in this series we are going to discuss about the CCPA, the California Consumer Privacy Act, and the issues related to it. So let's start with Mike with a brief overview about the CCPA, what people all around the world should know about this new regulation.
Very good. Thank you, Alessandro. It's a pleasure to be here with you today. And I think that the CCPA, and the official name is the California Consumer Privacy Act of 2018, is a remarkable piece of legislation which is brand new to the United States and is really the closest thing right now in the United States that we have that would be comparable to the GDPR legislation, and the fact that it is all-encompassing and protects consumers, and that it's meant to protect consumers. In the United States, I think it's important to note for the listeners that there is no overarching federal law that would apply to the entire country. Right now it's sector-specific and state-specific. So the fact that California now has this overarching consumer privacy law is very significant, because there is no other federal law in this space that covers consumers generally. So that is very significant, especially when you think about the fact that depending upon who you listen to or who you read, California has about the 6th largest economy in the world. So it's very important when California has a statutory scheme that puts into effect. It's very important that people take note. A lot of companies are going to be caught up in this, and so that is why it's so significant. First of all, who does the CCPA cover? Well, CCPA is going to cover businesses that sell to California consumers. And generally speaking, a California consumer is going to be a California resident. Okay, so if you're a business that is selling to California residents, then you might be caught up in the CCPA legislation. Now, just because you do business in California doesn't mean that necessarily you're going to be caught up in the CCPA. There's a couple of things that we need to think about first. First of all is that if your business does over $25 million in annual revenue, then it will be caught up in the CCPA. If it doesn't do that much, then it won't be. And so that's an important part. So small businesses aren't going to have to be caught up in the CCPA. The second part of it is that if you sell at least 100,000 customers' records throughout the year, so if you're buying or selling that information, you could also be caught up in the CCPA. Or finally, if you derive at least 50% of your annual revenue from consumers' personal information, you could also be caught up in the CCPA. So those are 3 ways that you can be caught up in the CCPA if you're using California consumers' personal information. So that's the businesses that will be caught up in this. And if you're caught up in this, the CCPA provides specific rules in how you can and cannot use the information, the notices that you have to give to consumers, and then also certain rights that consumers have. And so it's important to note then what type of information is caught up in this. And under the CCPA, personal information is defined as information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So when the add-on there is the household, so it makes it very interesting that if any information falls into that bucket, it will be deemed consumer information, personal information, and is caught up by the CCPA. That includes identifiers such as name, address, unique personal identifiers, email addresses, social security numbers, driver's license numbers, geolocation information, sensory data. And the one that I always think is very interesting is the one that's called inferences drawn from personal information. So it's not just the personal information, but that's a long list that we just went through, but it's also the inferences drawn from that personal information. So if you're a business that that falls into one of these three buckets, and you're doing business in California, and you're collecting personal information, you're going to have to pay attention to this rule, and you're going to have to get compliant. I like to break the CCPA down into two major areas. And just for my own mental well-being, I like to think of it as having legal obligations and also logistic obligations. And what I mean by that is that there are legal rights that it mandates companies provide to consumers, but at the same time, there are logistical requirements that companies have to implement internally in order to make sure that those rights are being recognized for the consumer. Okay, so that's really important to think about. And the first of the rights is that that California consumers have to be notified of the types and categories of data that a company is collecting. Okay, so a consumer has the right to know at the time of collection. That goes to a privacy policy or privacy notice that a company would be providing, that at the time of collection, the consumer needs to be notified of the specific pieces of information, the categories of information, and the purpose for the collection of the information from these entities that are collecting the consumer information. But not just that, they also have to be told of who they're going to be sharing that information with. So companies have to provide the categories of companies that they will be sharing that information with. And if the company is going to be selling that information, which is an interesting definition in and of itself, anyways, under the CCPA, they have to let them know the categories of the companies and the purpose for selling that information. So that's a lot of information that needs to be shared with the consumers. And the consumer has the right to know that information. But not just that, the consumer under the law now also has the right to not just be told that at the time of collection, but also has what's called the right to know under California law, which means that upon request, a consumer can request from a company the pieces of information that company is collecting on them. And once again, they can request the categories, the specific pieces, and not just that, but also the companies that they're sharing that information with. And along with the right to know is the right to delete, which means that, and let me back up for a second. With the right to know, there is a look-back period. There's a look-back period of 1 year, which means that right now, as consumers are potentially putting in requests to companies about the information that they've have on them, the company has to go back from a year from today to give them that information. So it's not just the information that you have as of today or as of the day of the request. The look-back period is a year. So that means that companies today, even though the CCPA only started in effect in January 1st of this year, are still having to look back to last year's information so that they can comply with the request. So that's the right to know. And then it's not just the right to know, but consumers also have the right to delete. And what that is that consumers can request that companies delete the personal information that they're keeping on them. Now, there are specific exceptions to that, so it gets very involved because, of course, there are incidences when companies will be collecting a lot of information from consumers that they need in order to do business, that they need in order to fulfill contracts, that they need for security purposes, that they need to maintain an account. Certain requests to delete are not going to be able to be honored, but the law and the regulations, the draft regulations that the Attorney General for California has put forth, has gone through proposed regulations on how to sort all of this out. So the last major right, so we've gone through the right to know and the right to delete. And by the way, with the right to know is kind of caught up this right of access or data portability. It's not really called that, but with the right to know, if you're providing to someone, this is the information that we have on you and that we've collected in the last year, then essentially you're giving them the right to access and you're giving them the right to portability if you give that information to them in a way electronically that they can then provide to another organization. So finally, the last major right that's new really is the right to opt out of a company's selling of information. And this is a very significant right. And once again, it gets into what I was discussing as being one of the interesting portions about the CCPA and exactly what is selling under the CCPA. Typically, in layman's terms, we would think of selling being I have a product and you give me money, I give you the product. But under the CCPA, selling means selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally in writing or by electronic or other means a consumer's personal information. And that's by the business to another business or a third party for monetary or other valuable consideration. And that's really why this is a significant definition, is because that's a lot of companies that can be caught up in that. It's not just for money. So the whole part here of for money or other valuable consideration potentially brings in a lot of organizations under this definition, which is important because it also makes companies want to get their agreements. They're going to have to get their agreements with vendors and other third parties organized in a way so that they don't fall under being a seller if they're really not doing it for money. If they're just providing information for someone to do business for them, they can draft their agreements in a way that so they be deemed a service provider instead of a business or a third party under the statute, so that they wouldn't fall under selling the personal information, which is something that one of the big news items is Facebook's stance on this, because Facebook deals in personal information, and as I understand it, their current position is that that they're not a seller of information, and so that means that they wouldn't have to give consumers the right to opt out of selling their information. Okay, and as we just said, selling can mean any type of making available essentially to another organization. So when a consumer, if a entity that's caught up in the CCPA does sell personal information, then they have to give consumers the right to opt out of selling that information. And if they fall under that category, they have to make it available, the process of opting out. They have to make that available to other consumers.
Okay, perfect. Thank you very much, Mike, and thank you for this brief introduction to the CCPA. We are going to discuss about what companies should do to comply with CCPA in our next video. So stay with us, stay tuned, and follow Privacy Rules.